Good morning, everyone. Welcome back to the lecture series. In last lecture, we have discussed about the who are the applicants and where you will file an application or filing an patent office. In this lecture, we'll discuss about the essentials of patent filing, that is forms of filing in India, and which is explained in the section 7 and 8. So far our journey was to understand about what qualifies an inventions and who are the legal authorities to file an applicant. Now let's move on to this understanding the stages of filing a patent, that is of forms, the documents and the timeline which is initiated to initiate which is initiated to for a patent application under the Indian Patent Act. So, Form 1 is an application for a grant of patent. The Form 1 displayed with the key sections highlighted that once a requirement is filing for process of Form 1 begins, which is the application for a grant of patent. The Form 1 is formally initiated for the patent filing before the patent office. So, however, for filing the Form 1, we must be very clearly understand that who is the applicant is and who can be the applicant. And like already we have discussed that in last lecture that who will be the applicant, like inventor or or legal representative of uh, deceased assignee, or else applicant, and the company can be of us also applicant. So in this practice, that very common for inventor to assign their inventions or the patent rights to the another person, or this could be the company where they work for the business or the business partners, and any other interested entities. As per this law, the applicant can be of a true or the first inventors, or this an assignee or a legal representative of the true or the first inventor. So the proof of right to apply, which just has to be assigned if we are giving as an assignee or as a legal representative. For example, when the applicant is an assignee or a legal representative, the law requires them to submit the clearly established the document of what are the rights to apply. That is a deed of assignment. We say as a proof of rights, and another valid document is clearly indicates that the inventor has assigned the right in the inventions to the applicant. Alternatively, inventor themselves may assign the form 1, stating that the invention has assigned to the applicant. In such cases, the form 1 itself will act as a proof of the right to apply based on the assignment made by the inventors. That is proof of right to apply, whether it is an assignment deed or the signed form 1, must be filed either at the time of filing or within the 6 months from the filing date. So, the filing this document within the prescribed timeline is an extremely important, as it is a legally establish the applicant authority to file the patent application. So next is the form 5, that is declaration of the inventorship. So the next, like moving this, when the inventor is not an applicant, then there is a one additional requirement. The application must file a declaration form that they, to the best of their knowledge, the listed persons are the true or the first inventors. This is done by the form 1, knowing that the declaration of the inventorship or as required under the section 7.3. So it is important to understand that to distinguish clearly that Form 1 is signed by the inventors, assigning the rights to the applicant. Form 5 is then signed by the applicant, declaring that who are the true and the first inventors. The Form 5 must be filed along with the application or within the 2 months from the filing date. So, for the deed of rights, we have to file within the 6 months from the date of applications. But in the form 5 we have to submit within the 1 month from the filing date. Next is the form 2, that is specification of the inventions. So always we have the two types of specification. One is provisional size specification, another is a complete specification. So once the ownership and the inventorships are clearly established, the next requirement is to describe the invention itself. This is done by using the form 2, which contain the specification of the invention. At the time of filing, the applicant has the two options. One is filing the provisional applications, or else the filing the complete specification. The professional specification helps to secure the early priority date while the invention is still being refined. So, we'll the detailed discussions we'll see on the later videos. However, the one important thing is we have to know that if the application is a conventional application or the PCT applications, national phase application, a provisional specifications cannot be filed. In such cases, filing the complete specification is a mandatory. So next, the form 3, which is the disclosure of the foreign filing. Like a patent is like territorial in nature. This means that if you require the protection in the multiple countries, the applicant must file a separate application in each of those countries, or else like he can submit as a one application which it can be act as a protection for the all the countries. Because of this, the Indian Patent Office is requires the applicants to disclose their details to all the foreign patent filing using the form 3 under the section 8.1. Form 3 is stating the undertaking in which the application provides the details such as the application number, filing date and country, and the current status of the corresponding filing application. Initially, the Form 3 must be filed within the 6 months from the date of filing the Indian application. Any new foreign filing or any new development in the existing of foreign application must be reported to the by filing as updated in the form 3 within the 6 months of such changes. If you have done any changes in the application when you're which is filed in the foreign applicant, you have to update the changes within the 6 months, whatever after the changes has been done. Further, the controller also will request for the additional documents such as the foreign search report and examination report objection raised by the foreign patent office. This must be submitted within the 6 months from the date of the controller request. So next is the Form 26. The Form 26 is the appointment of the parent agent. Consider if we are the foreign applicant and we want to communicate with the Indian office, then we have to appoint a parent agent. So the considering the procedural complexity and the strict timeline is involved, always we will not be having the proper monitoring, so we can appoint as a parent agent in to act in behalf of us. So to legally authorize the patent agent, the form 26 has to be filed. Once the form 26 is filed, all the official documents will be from the parent office will be directly communicated with to the parent agent, so who keeps the applicant informed of all the development. To summarize this, the basic form is to initiate the patent filing in India. For the Form 1, Form 2, Form 3, and Form 5. If we are appointing an patent agent, then we have to fill the Form 26 is also required. So the key section of Section 7, which deals with the who can file an inventorship declaration, and the Section 8 is governs the disclosure of the foreign patent filing. So far we have seen the clear understanding of who authorized to file a patent application, and what are the documents required to be filed, and what the timeline has to be followed. So the further in next sections we'll see about the and further sections. But I want to conclude with this point that Form 2 is for the detailing drafting of an strong application, that is of provisional draft is strong provisional or the complete specifications. So in next lecture we'll see about discussing about the provisional patent applications. Thank you.